Hadro is the senior Washington, D.C. correspondent for the Catholic News Agency, or CNA. His reports on this issue have appeared there as well as in the National Catholic Register. Thanks so much for weighing in today, Matthew. Can you summarize what Roe v. Wade and Planned Parenthood v. Casey did to give us this history of abortion in the United States?
So the court in Roe ruled that the constitutional right to privacy also protected a woman's right to an abortion, as the court found it. And so the court said that states could not ban abortions pre-viability, the standard at which an unborn baby could survive outside the womb. The court said that during roughly the second trimester that states could regulate abortions. And Planned Parenthood v. Casey 20 years later built upon that and said that states cannot pose an undue burden on a woman's right to an abortion, as the court sees it, while regulating it.
So we're talking about privacy stretched out to give a right to abortion then through undue burden. Can you give us a background on this Mississippi case? When did it start and how did it get all the way up to the Supreme Court?
So in 2018, the law was enacted in Mississippi. It was challenged by a pro-abortion group who was representing the state's only abortion clinic. And the lower courts ruled against the law and prevented it from going into effect. So the state in 2020 appealed to the Supreme Court, asking it to take up the case, and the court on Monday agreed to take up the case.
So within 2 years, they went all the way up to the Supreme Court. And this group that you said is representing the party in Washington, they're out of New York, I believe?
Yes, I believe that's right. It was the Center for Reproductive Rights.
The Center for Reproductive Rights, that's right. Would the Supreme Court have taken this case if they didn't want to do something with it? Why else would they have taken this?
It's very interesting because, several times recently the court has declined to hear appeals from states regarding their abortion bans at, bans at 20 weeks, at 12 weeks, as early as 6 weeks. So this is really a significant development that while those previous laws were struck down in the lower courts and the Supreme Court would not hear the appeals in those cases, now the makeup of the court is different. You have new Justice Amy Coney Barrett, and the court is now agreeing to consider Mississippi's law, which effectively bans most abortions after 15 weeks.
And you hear all the time a direct challenge to Roe v. Wade, a direct challenge to Casey. This isn't necessarily a direct challenge, but should it be a victory, would that be, what comes next then? Is that a missive for the states to get involved? Is that something that would have to be codified into federal law?
Well, it's again, those are good points you made. President Biden has promised to codify Roe v. Wade in federal law if Roe were ever to be overturned at the Supreme Court. The laws, if that were to happen, the laws would go back to the states. Some legal experts are also saying that the court might not outright overturn Roe, but it could effectively gut it if it chooses to repeal the viability standard, which was kind of central to the Roe decision, and really which is the question that the court is considering in this case, is whether all restrictions, all prohibitions on pre-viability abortions are unconstitutional or not.
So then what's next? We're going to hear oral argument at some point?
Yes, oral arguments will be in the fall.
In the fall. Okay, well, we'll be watching this closely. Thank you so much, Matt.